He said he needed a little more time, and then it came through by the end of that point. I understand your Honor's position that more communication would have been ideal. I could approach and tell you some other factors, but that doesn't quite matter for our purposes here today. Ultimately, Judge, once we got it, the priority was to jump into it just to make sure of what there was and to start assessing that and sort out what belonged to Mr. Garlington.
What do you, at this stage, having had 5 days to assess the narrowed evidence, suspect that your motions in limine are going to entail?
Judge, I just wanted to, there are several, at least I think several videos, including Mr. Garlington, that look like YouTube videos of some form. I just want to review them in light of recent case law regarding presentation of lyrics and things like that to see if that was, if it comports or not. That would be the biggest issue I want to look at a bit more closely.
All right, I need that filed by Monday at noon.
Understood, Judge. Thank you.
What else? You think there's going to be anything else?
Not that I can think of, Judge.
Okay. Anybody else? No motions in limine for anybody else? All right. I want, I need you to speak into the mic, identify yourself and your party.
Attorney Eric Johnson for Mr. Christian Eppinger, Your Honor.
All right.
I would just ask to join in the co-counsel's argument in this particular matter as it relates to the discovery in this case and be allowed to, till Monday, to file them as well.
What motions are you anticipating filing?
At the present time, Your Honor.
Pick up your mic and speak into it.
At the present time, Your Honor.
Thank you. That is so much better.
Thank you. I can't say at the present time. I've not finished the recitation of we're going through all of the condensed version of the evidence, but I would just ask for leave till
Okay,
Monday.
y'all realize the condensed version of the evidence is less evidence than it was before. You already should know the entire universe of the evidence and know, okay, if this evidence is still going to be presented, here is the motion in limine that I need to file to address it.
Well,
so you shouldn't still need, you should be able to tell me it's going to be these three or this one, or maybe it won't be any because that evidence isn't here yet. You shouldn't just now be like, I think I need to figure out what to do with this evidence.
No, I'm not saying that I need to figure out what to do with the evidence, Your Honor. However, in order to provide proper representation for my client, I have to go through all of the additional evidence to make sure that it's the same as the first evidence, to make sure that there's nothing been included that was not in the first part of the evidence.
Let's pause for a minute. Is there any new evidence that wasn't included in the last drop of evidence?
No, Your Honor.
There's not any. You don't need to worry about that.
Thank you.
And Mr. Dart.
Yes, Your Honor. I just wanted to draw the court's attention. I would like to join in the defense request as well for time to file a motion in limine. I did see those same YouTube videos, Your Honor. I have gone through some of them. They do, for the most part, so far what I've seen, look like just music videos, rap lyrics, things like that. But, Your Honor, because it's, by my count, I counted just in stuff just related to my client, 250 plus social media posts, and I was still counting, but 118 plus videos that all could or somehow potentially relate to my client with respect to this argument. So, Your Honor, I would just ask for time to get through all of those. I do also, Your Honor, submitted a motion.
Yeah, we're going to talk about that too.
Correct.
Okay, so it does not need to be ex parte, and you want funds for an investigator and a gang expert. And here is what, and I know that you were appointed July 19th of 2024, but July 19th of 2024 was 6 months ago at this time. I told you in December that we were looking at a late February trial start, and that you had and would have more than enough time to get your case ready. This should not be the day that you are for the first time saying, oh, you know what, I think I might want some assistance. Let's review, and y'all have all been before Judge Dempsey for the last 8, 10, 12 months on this case,
Your Honor,
except for you, who started in July, 6 months for you. And you should have, as soon as you got into the case, reviewed everything that had already gone on in the case. And in September of 2023, an order specific to your client was entered by Judge Dempsey saying that defendants pending motions, nobody had done anything on them, and they were not going to be before the court any longer. January of 2024, a scheduling order entered in this case applicable to everyone. The deadline for the state, if you interrupt me again, we're going to have a problem, okay? I am talking.
I understand. Yeah.
The deadline for the state and the defendants to file any additional pretrial motions is February 6, 2024. Now, I know you weren't in the case February 6, 2024, but when July rolled around and you reviewed what had been filed, you at that time in July or early August should have come to Judge Dempsey and said, Judge Dempsey, I'm new in this case and I need funds for an investigator. In May 14th, 2024, Judge Dempsey, no further pretrial motions will be considered by the court. I told you all in December what the deadlines were going to be. And every one of y'all is like, oh gosh, you know what? I think I need more time. I just find that to be problematic. Very problematic. All right, turning to the state here for a minute. I got this morning a chart of what maybe the redacted indictment is going to look like by the time we go to trial. And I'm honestly not sure I even understand it. So have y'all been able to redact the indictment yet or come up with what you think it's going to look like or what counts you're going forward on?
Yes and no. So I'm working on the actual redacted indictment. It's been time consuming because I'm trying to make it.
Okay. Can I ask a simple question? I hope a simple question that might clarify things for all of us. Do you still plan to go forward on count one, the RICO count against anybody?
Yes, Your Honor. But we made, so the very first, I guess, chart that you're looking at on page 1, I believe the original, in count 1, there was 191 overt acts. I've reduced that down to 63 overt acts.
Okay.
And so I think that's going to consolidate and shorten the trial immensely as it relates to the previous trial that Your Honor presided over. Mm-hmm. And as I continue to redact the indictment, there may be a few overt acts that I can also erase based on the fact that Mr. Mender did take a plea on Monday or Tuesday of this week. But I will have the redacted indictments, Your Honor, first thing Monday morning, Your Honor.
All right. Do the defense attorneys have this somewhat confusing chart?
Yes, Your Honor.
Yeah?
They do.
Okay. Is it any less confusing to y'all than it is to me?
I can help try. I mean, it's count 1, and then there's an act. The box says act. Those are all the acts that we'd be going forward on count 1.
Okay.
If you flip to page 3, each one of those contains the actual count in which each defendant is charged with, and that will, that's what we're going to be moving forward with as it relates to each one of the remaining defendants as it relates to the counts.
Okay, so the first 2 pages are just what count 1 is going to look like, although maybe even shorter.
Yes, yes.
And then basically the remaining, the substantive counts, if you will, against each defendant, those are listed on the last page, page 3, and those basically stay the same. Is that right?
Correct, Your Honor. And
okay.
Each one kind of has a short summary as to what each count or each overt act covers as it relates to the previous indictment and the incident or the act.
Okay. All right. And have the parties exchanged their narrowed witness lists?
Not yet. But we can get that done fairly quickly as it relates to each act and
Okay.
fairly.
So this is not really the pretrial conference. This is the pre-pretrial conference. Okay. Mr. Dark, you had said within your motion that you didn't have anything other than names for any of the state's witnesses. Is that accurate? And if that's the case, have you talked to counsel for the state about that?
Your Honor, when I look through some of those things, I'm sorry. Your Honor, when I look through some of those things, there are some witnesses that are listed in parts of the discovery where it is a name only, but there are some where more information is provided. I did send an email to Mr. Abadi related to a separate discovery issue where some aspects of the discovery are completely inaccessible to me.
Inaccessible.
I can't open them at all or download them or anything. And so we're trying to work through that. He did tell me that he would either try to reserve it or get me something else, I think today or this week. But, Your Honor, that was the basis for me making my request. I need assistance going through all this
You
stuff.
told me in December you were having some problems with that, and that should have been cleared up in the month between then and now.
Well, the issue with that is from what I understand, and I'm not trying to put words in anybody's mouth, but I can at least speak for Mr. Dark. It doesn't sound like he's been through the original discovery that was served to him, and it all works in that. It was very time consuming for me to then basically do it again, but narrow it by moving it to a different Dropbox link. That took me literally 29 hours is what it says. And Your Honor had given me the deadline for the first full week of January, which the last day of the first full week of January is January 12th, which is when I got it to him.
Okay.
I had my personal issues where I was dealing with the family members, oncologists, and things of that nature. So that was more important, to be perfectly honest, than getting it before the end of the first full week of January. So he's clicking on the link, he's saying it on the new discovery link for the narrow version. You can go find it in the full one, but I will make sure that I look at the new link and remedy any issues that I learned about this morning, because that's when I learned about the issues, was this morning, I think around 8:30.
There does not seem to be any kind of advanced communication between anybody, between counsel and counsel, between counsel and the court. Communication really does help, because then we know what we're dealing with before we get to court.
Well, Your Honor, to that point, I emailed Mr. Abadi several times prior to today. When I first got on the case, I asked for discovery a few times. There's several emails that have gone unanswered. I understand Mr. Abadi has a heavy caseload. He has personal matters. I have 5 children. I have a heavy caseload as well. But I am simply trying to give my client an actual defense, a robust defense, and I need assistance to do that. So that's the basis of the request. I have no problem going to find anything, but I need assistance to do that, because unfortunately I don't only have this case. I am appointed counsel in several other courtrooms. I have a speaking trial before Judge Potts, and that client is entitled to defense as well. So, Your Honor, that's the basis of my request, and I know that my client would greatly benefit for just having some assistance on this case. Otherwise, it's almost a forced mistrial, or it's almost a forced ineffective assistance.
You setting that up right now for us, given what you keep saying? I would really like for you to do that. You should have been working on this case since you got it in July.
I have been, Your Honor. I
Right.
really have. I've done way more than 29 hours. I can assure you that.
I would certainly hope so.
I think we all have, but we're still waiting on the 8 terabyte, USB, whatever you want to call it, that we requested the defense counsel, like every other counsel, had to provide. And we've done our best through Dropbox, but the surefire way to make sure everything works is to provide the 8 terabyte USB, whatever they're called, like we've requested, and nothing has gone unanswered. I've responded to each email that the defense counsel has, despite the fact that one was sent this morning. That's the only one I haven't been able to respond to.
Can you go ahead and provide the 8 terabyte, whatever it is, so that they can give all the discovery back to you on that?
Your Honor, I think that was partly included as a basis for the request for funds, but if worst case scenario.
I'm happy to give you some funds so that you can go out and buy one of those.
Yes, Your Honor. I would need that, and then I could most certainly do that.
Even though it is not anywhere in your motion, but, yeah. Mr. Johnson.
Yes, Your Honor. In speaking, prior you were speaking with regards to the redacted indictment in this matter, and then looking at the charges that are listed for Mr. Eppinger, I'd just like to bring the state's attention that count 35 against Mr. Eppinger was dismissed prior in the earlier trial, prior to his severance in this matter, and I still see it listed as the possible charges here, but that count was dismissed earlier by Judge Glanville prior to Mr. Eppinger's severance in this case.
Okay. Y'all check into that? Do you happen to know like a date or was there a written order or anything like that?
It was during the wild commotion of jury selection, Your Honor. I don't remember the exact.
Okay.